My name is Sithabisiwe Nikimo, a BA LLB student at Calcutta University. I'm going to present on the topic contracts and the essential elements of a valid contract. My presentation is going to be based on the Indian Contract Act of 1872 because it is the primary governing law of Indian contracts. I'm going to begin by introducing the Indian Contract Act of 1872 and then elaborate on the contract definition and the essential elements that are required. Introduction to the Act. The Indian Contract Act of 1872 is the primary law governing contracts in India. It lays down the legal frameworks for forming, enforcing, and interpreting contracts. The law ensures that agreements made between parties are fair, binding, and legally enforceable. Definition of a contract. According to Section 2H of the Indian Contract, a contract is described as an agreement enforceable by law. This indicates that a contract is not merely any agreement, it carries legal value that can be upheld in a court of law. A contract is established when two or more parties reach an agreement with a shared understanding and an intent to create a legal obligation. For example, if I promise to gift someone a car, then that represents a social agreement. It is not a legal contract. But if I get into an agreement to sell my car for 5 lakhs, then that is a legal contract. An introduction to essentials of a valid contract. What makes a contract valid? Let's get deeper into it. Every agreement is not a contract. For an agreement to become a valid contract, it must meet certain conditions laid down in Section 10 of the Indian Contract Act. These are known as the essentials of a valid contract. Let's look at them in detail. The first essential is offer and acceptance. There must be a clear offer made by one party and a definite acceptance by the other party. This mutual agreement is the foundation of any contract. Both offer and acceptance must be communicated properly and understood clearly by the both parties. We go on to another essential, which is intention to create a legal relations. The parties must intend to enter into a legal binding agreement. Social or domestic agreements do not usually qualify as contracts because they lack this intention. Another essential is lawful consideration. Consideration means something in return. Each party must give or promise to give something of value. The consideration must be lawful, not immoral or illegal. And then the next essential is capacity of parties. According to Section 11, parties must be competent to the contract. This means they should be of sound mind, not minors. They should not be under the age of 18 years and not disqualified by any law. We go on to essential number 5. There must be free consent. Consent must be free and not be caused by coercion, undue influence, fraud, or misrepresentation. The consent must also not be missed by any mistake. If consent is not free, the contract becomes voidable. Another essential is a lawful object. The purpose or object of the contract must be legal. Agreements made for legal or immoral purposes are not valid contracts. Another essential is the possibility of performance. The contract must be capable of being performed. If the act is impossible to perform, the agreement cannot be enforced and it is not a valid contract. The last essential that we have is it must not be declared void. The agreement must not be one that is expressly declared void under the law. For example, it includes agreements in restraint of marriage, trade, or legal proceedings. So, to conclude it all, this was just a simple overview of what makes a contract valid under the Indian Contract Act of 1872.